So for the next, we have like an hour and 15 minutes left available to talk about the amendments and also related implementation. Ken and I will be walking through this, and I'm also encouraging Paul to assist us in addressing any questions that come up related to this. I'm going to be doing a pretty general overview. So you may have some specific questions that we may be able to address. Some of them may be so specific or ones that we want to take some additional time to consider, but certainly this today, as well as, the coming weeks, the coming 5.5 months leading up to the implementation is the time to get those questions out there, and we will take them and incorporate them into guidance, into training, into Q&As that we'll be putting out there. We also recognize that in this transition period, people are working on sites. They're trying to think about potentially closing sites under the current rules and how to do that, or the implications of the new rules for sites that they're working on, and it won't necessarily be helpful to wait for future Q&As if they have a question that's coming up now. So we encourage you to send those questions along to us. You can send them to Ken. You can send them to me. You could send them to BWSC information or regulations, and you'd put MCP 2024 or something to that effect in the subject line, and we'll try to get back timely responses on questions that are coming up in the work that you're doing. So with that, I think I'll start with just some background in terms of where we've been and how we got to this point. As you know, that the MCP amendments that we're now referring to as the 2024 amendments, actually we first started putting together this package of proposals and put them out in public hearing draft in 2019. So it's been some time, probably for most of you, since you focused on what was in there. So this will help be kind of a helpful reminder of what was in the package and any changes we made from the public hearing draft to the final amendments. So I'll first direct you to where you should go for information. If you haven't already, we have one page posted with the 2024 revisions. It contains both the final, it contains several different versions of the amendments. There is a clean copy, so you can see all of the changes incorporated. There's a red line version that shows you the changes from the current regulations to the final. Everything that changed appears in red line. And then there's a version that shows you changes from the public hearing draft to the final. So the red line is just those adjustments that we made based on our review of comments and incorporation of those comments. Just a little bit about how it is posted and what's posted. These are the unofficial versions of the regulations. They're not the Secretary of State version. With the Secretary of State on September 1st posted a notice directing people to our website. And because we have this delayed effective date, their preference was to direct people to the website as of September 1st, and then they will publish the final amendments in full in the register when they go into effect on March 1st. So that's a little bit different from how we may have done it in the past. We used to have provisions that would talk about a delayed effective date in the MCP, but their preference is not to handle delayed effective dates in that manner at this point. So that's why the notice pointing to our website. So this page is also where you can look back as we post related guidance. We'll be putting it here or linking it here so you can find it. When we put significant pieces of information up, we will flag those with an email from BWSC information. So this is sort of the home page for the implementation of the 2024 amendments. To remind you of the context for these amendments, so as I mentioned, they began with public hearing draft back in 2019. Those of you who have been with the program over time know that we have routinely updated the MCP to keep our standards current with updated toxicity information, also to reflect changes in standards of practice, and to look for reducing unnecessary process related to submittals and such things. So this is a routine for us to keep the MCP up to date. I know it comes at it brings benefits in terms of having a set of regulations that is responsive to changes over time. But it has the and the work that's involved in implementing the changes and bringing everybody up to speed on it, and the challenges associated with that. The proposals that we had put together back in 2019 were included proposals that had come from the regulated community, some related to compliance concerns that MassDEP had identified through our review of site work, audits, and enforcement, and then some clarifications and modifications that were follow-up to the last time we did a comprehensive set of amendments back in 2014. I would encourage you, if you're digging into something and trying to understand the change, that the public hearing draft is useful for that purpose. We still have it online, and what it contains is our, in most cases where we made something other than a clarification or a minor clarification. In most other proposals contained a note to reviewers that explained our intentions with what was being proposed. So I would go back to the notes to reviewers if you're interested in getting some understanding of the change. Actually, I want to back up just a little bit. So another place to get information about changes is also posted on the 2024 amendments page is our response to comments document. There are two documents. One is a summary memo. It's really focused on those proposals that received the most significant volume or significant type of comment. So there's that summary memo, and then along with that, there's a detailed comment by comment response to comment document. So you can see we've pretty much verbatim copied in the comment that we had received, written comment we received, and then provided a response to that and indicated to what extent it affected how we had changed the original proposal in the final amendment. So I mentioned the response to comment the public hearing draft and notes to reviewers. The timeline for this set of amendments, they started out as part of a package that contained proposed reportable concentrations and cleanup standards for PFAS compounds. We held 4 public hearings at the time, back in the spring, summer of 2019. Much of the both the public, the testimony, and written comment, as you can imagine, was focused on the PFAS compounds because that was such a significant change. At that point in the fall of 2019, we decided to move forward with finalizing the PFAS changes because the department was also moving forward with establishing drinking water standards under the drinking water program for PFAS. So in December 2019, we finalized the MCP related PFAS changes, and with the rest of the changes that we're going to talk about today, not still pending in terms of finalization. With respect to the non-PFAS related proposals, we received 20 comment sets and about 300 individual comments. Most of the proposals receiving the most comment, by and large, risk characterization related proposals were the topic that received the most comment and very detailed comments. And then kind of collectively, these other topics here, tier classification, temporary solution and status reports, active exposure pathway mitigation measure related proposals came in second in terms of the amount of focus of the comments. And as I had already mentioned to you, there is both a summary memo and a detailed response to comment document posted. So now I will begin to walk through those proposals. I'm just going to highlight ones that are significant. I'm not going to be able to cover all of the changes in the document, and this is, as I mentioned previously, this is going to be an overview. It's not training. We won't get into that level of detail, but just to remind people what was proposed, mention some of the comments that we received where it led to changes in what was proposed to what was final. So starting, and this was probably the area of the proposals that did receive the most comments, were proposals related to updating the methodologies for sampling and estimating exposure point concentrations in soil. This was focused on those situations, those types of sites where the contaminant distribution and variability had no clear pattern or connection to sources. So this was the intent of this was to ensure that these types of sites were being appropriately characterized in terms of estimating the risks posed by them. We had proposed using an approach related to sites where systematic sampling would be done and estimating the exposure point concentration using an upper confidence limit on the mean. I think our proposed approach was less flexible than what we've ended up with in the final regulations. We did, after we put the public hearing draft, hold a couple of additional meetings to meet with people that had provided comments and get some additional feedback. One of the suggestions that had come out of those discussions was that we more clearly identify earlier on in the risk characterization process when someone should be considering whether to do systematic versus judgmental sampling. Judgmental sampling being what is done where the source area and you have a defined area of contamination and you're able to bias your sampling towards that area of contamination. So in the final regulations, we did do that. We earlier on in subpart I, there are provisions related to considering which sampling approach should be used. I think in the final regulations, we were much less prescriptive about making that decision, more flexibility, more professional judgment in how that is done. And we define that where systematic sampling is done to allow the use of discrete sampling using the 90th percentile Chebyshev non-parametric upper confidence limit on the mean, or incremental sampling, or alternative approaches, provided that some technical justification for why that alternative approach is sufficiently conservative is provided. Related to this, we made a change in terminology that we carried all the way through the regulation to avoid confusion. Now that we are referencing upper confidence limit on the mean, so that we wouldn't have references to two types of UCLs in the MCP. So we changed our method 3 upper concentration limits to method 3 ceiling limits. We also had proposed an approach to address manufactured gas plant waste at sites to ensure that they were that the waste associated with them was appropriately accounted for in the risk characterization. The aim with that was to address coal tar waste as a mixture of high concentration of toxic, what we would consider otherwise gross contamination at a site that is there as a separate semi-solid phase within the soil matrix. So not considered part of the soil or part of the groundwater, but considered separately. One of the issues with the current regulation is while we think coal tars would be considered types of material that would otherwise exceed upper concentration limits in most cases, the current upper concentration limits provisions are specific to soil and to groundwater. So there was it was not clear that it would apply to coal tars at a site. In the initial proposal, we used the term manufactured gas plant waste and other waste. In the final regulation, we narrowed that to focus on what was really our primary intent, which was coal tar waste. We had proposed to deal with it by defining it as a hotspot, and we moved away from that approach, and instead we addressed it in a separate section, which is looking at it in terms of the risks it posed to public welfare and the environment. Very much the same way the upper concentration limit section does in the current regulations. We allowed for a qualitative assessment of visible coal tar waste deposits. That is to address concerns about the limitations in terms of analyzing this material and the potential to foul analytical equipment. So the regulations provide for a qualitative assessment of is it present as visible coal tar waste deposit. And as I said, there is a new section that defines the conditions that would be support for public welfare and the environment, a permanent solution, as well as a temporary solution. And this section does make reference to the engineered barrier provisions in the same way that the current upper concentration limits section does in the current MCP.